keep the mind where on the last day, try to help so that we can.
Thank you, sir.
The minister should have thought about that. We have only 1 hour for this.
Now it's over.
He has taken half an hour
Now
in
over.
the beginning. And you will have to...
Hey, please, please. Now it's over.
15 minutes.
Now it's over.
15 minutes.
There is no need to reply, yaar.
Sir, I thank the minister for
please.
leaving some time for us.
Okay, I understand.
Sir, as I said last time, the
See how Jairam Ramesh will articulate in such a crisp manner in short time. Everybody should follow him.
Sir, I obviously rise to support this bill, which is converting an ordinance into a legislation. And as I have said earlier, and which the minister quoted, this will not be the first, this is the second occasion. There will be other occasions as well, because we are learning as we are going along, because this is new territory for us. Insolvency and Bankruptcy Code has been a major shift from past practice, and therefore new experiences, new problems, new challenges, and I welcome the fact that these changes are being introduced. So I have 5 very specific and very pointed questions of the Honorable Minister. Some of these questions he may not be able to answer. Some of these questions the officiating Finance Minister may perhaps consider for answering. So the first point, in the last 2 years, there are about 700 cases that have been admitted under the Insolvency and Bankruptcy Code. Out of these 700 cases, only 3% have been resolved. 12% have gone into liquidation and 10% has been closed. In other words, out of 700 cases, over 500 cases are active. Now the code says within 270 days, the process must be complete. So my first question to the Honorable Minister, isn't this a very high proportion of cases that are still ongoing? This is not meant to be a criticism, because a lot of this has got stuck in litigation. But we need, as Parliament, we have passed a law which says that in 270 days, the whole process will be complete. But here we have over 75% of the cases which are still going through some process or the other, and I would urge the Honorable Minister to pay close attention to this. So the second point, I have looked at about 35 of these cases, and I find that the recovery rate for the banks is about 40%. Now, I don't want to use the word haircut, which is used by the Finance Ministry very frequently, because it's a very ugly word. It's actually recovery. We are talking of recovery of public money by banks. The recovery I find in these 37 cases is about 40%. Now, this 40% is also a very optimistic figure, because this includes recovery in steel industry, and steel, as the Honorable Ministers know, is cyclical. And now the steel industry is looking up, and therefore we are getting very healthy recoveries. I suspect, sir, that the recovery that the banks are going to get out of this Insolvency and Bankruptcy Code is not going to be more than 30%. This is not a very healthy figure. And I would urge the Honorable Minister to pay close attention to the fact that while there may be 1 or 2 cases where the recovery is very good, those happen to be in the steel industry. If you leave the steel industry aside, the recovery rates are not looking very, very healthy. So there are some cases where the bid value is lower than the liquidation value. This is very, very disturbing, sir. The bid value should be higher than the liquidation value, but in some cases I have found, and the ministers have access to more information than I have only access to public information, I have found that the bid value in some cases is lower than the liquidation value, and this is not something that we should accept for a long period of time. Sir, my third point, and this is directly pointed to the officiating Finance Minister, On the 12th of February 2018, the Reserve Bank of India issued a circular on stressed assets. So what this circular says is that even if you have defaulted by 1 day, that asset becomes a stressed asset. So I welcome that circular. The circular then goes on to say that if within 180 days a resolution plan is not finalized, you are then considered a defaulter. So I welcome this RBI circular. But I am amazed that the government of India has challenged the Reserve Bank circular in the Allahabad High Court. The hearing was held on the 2nd of August. And the government of India, obviously the finance ministry, has given an affidavit or has given some statement in the court which actually dilutes the Reserve Bank of India circular. So this is an extraordinary situation. The Reserve Bank of India is issuing a circular on stressed assets which is being challenged not by industry. It is being challenged by the finance ministry. It's being challenged by the government of India. Now, it's extraordinary that I find this situation, and I'd like the officiating finance minister to please clarify what is the exact position on this circular, because this has a bearing on the Insolvency and Bankruptcy Code. Can I just finish, please?
Let him complete.
No, it's very important clarification, because he's such a learned colleague of mine. Can there be officiating minister? Cabinet minister is a cabinet minister. Please, I need that clarification. Can there be under our system, when a cabinet minister is allocated a portfolio, do we have a minister or an officiating? I've heard this word for the first time. I want to know.
This is the word used by him. There is a cabinet minister. Yeah.
Sir, I was talking about this circular, and I would like clarity from the minister concerned, who is looking after the finance ministry now temporarily, as to what is the government of India's position on this circular, because the circular was issued by the Reserve Bank of India. It defines what a stressed asset is. It defines what a default is, and this has grave implications for the IBC. This is my third point. So my fourth point is that it appears to me that the Insolvency and Bankruptcy Code benefits the banks, obviously. It benefits the secured creditors, obviously. It benefits operational creditors at some point of time. It benefits the economy. We welcome it. But what about the promoters who have actually led to the asset being a default or an NPA in the first place? It should not be the case that the promoters go away scot-free. There are legitimate promoters who have got into trouble because of economic cycles. But there are also promoters, we know, who have defaulted willfully. And today, we heard the news, yesterday the news came that the Serious Frauds Office has actually apprehended one particular promoter whose name I won't take. No, but I do believe that this is a very important point. If the Serious Frauds Office has taken this step, I welcome and applaud that step, and I believe that we should use the Insolvency and Bankruptcy Code to call willful defaulters to book. While we are recovering for banks and secured creditors, we should not allow willful defaulters to go away scot-free. So in this context, I want to repeat a suggestion I had made the last time this amendment bill came up, last time the amendment was made through an ordinance, that the ordinance, the previous ordinance defined who a promoter is very broadly. But if we are talking about the MSME sector, so in the MSME sector, it is only the promoter who is actually going to be in a position to revive the MSME. So this is a difficult situation to be in, and I had, and the Honorable Finance Minister at that point of time had acknowledged this point and said that he would come back with some elucidation on this, and I would urge the Finance Minister to revisit this issue, because the MSME sector accounts for a large proportion in terms of numbers. In terms of rupees crores, it may be a small number, but in terms of numbers, it's a very large number. And if we are going to debar MSME promoters, you're not going to be able to get a revival of the MSME sector. I am not speaking on behalf of any willful defaulter, but I believe, sir, that in most cases, the MSME sector has become a stressed asset or an NPA because of market conditions and not because of willful default. So, my final point is this, that recently the Finance Minister announced Sashakt, a new program called Sashakt. Now, I don't see what the need for this Sashakt was when you have the RBI circular of the 12th of February 2018, and when we have the Insolvency and Bankruptcy Code, which we are amending from time to time as we gain experience. So I would like the Honorable Finance Minister to give us some clarity as to how Sashakt actually contributes to the objectives of the Insolvency and Bankruptcy Code. So these are my comments. I support the amendments. I support the conversion of the ordinance into the legislation.
Thank you, Ramesh.
And I expect that in the months ahead, as we gain more experience with the implementation, we will continue this process of fine-tuning,
Thank you very much,
both on the
Mahesh
IBC as well as on the GST, which has been very much on the anvil.
Thank you.
Thank you, sir.